be outside.
So, yes, so this is part 2 of a show that we began earlier today, talking about the decision of the United States Supreme Court on May 17, 2021, Caniglia versus Strom. It's a firearms-related decision that implicates the Fourth Amendment, where the court said that the community caretaking function does not justify warrantless entries into homes where no other exceptions to the Fourth Amendment apply. So just moving forward, we had discussed how Mr. Caniglia filed a civil rights action in the District Court of Rhode Island, and the court threw it out. He then went to the First Circuit Court of Appeals, and that court upheld the summary judgment granted by the District Court, and then he was granted cert by the United States Supreme Court. We were going through that decision, a decision that was written by Justice Thomas. It was a 9-0 decision. Thomas was joined by Justices Sotomayor, Kagan, Barrett, and Gorsuch in his opinion. Roberts and Breyer wrote a concurring opinion. Alito wrote a concurring opinion, and Kavanaugh wrote a concurring opinion, but they all agreed on the basic tenet of this decision that the community caretaking function does not allow police officers warrantless entry into homes. Thank goodness, because it seems like in the past 50 or 60 years, the Fourth Amendment has been whittled away and whittled away, where the exceptions have overtaken the actual rule. We were talking about Justice Gorsuch and his opinion about consensual entries and how consensual entries have become the norm rather than warrants, and that's kind of where we left off, right, Ed?
It's Your Honor.
No, I don't think it's Your Honor. We're going to get to this in a
minute. Wait a minute. Out of order.
The reason Ed is dressed up
out of order
is because as we began the
You're
first part of our show, we were
Marshals, stand by.
You're scaring the puppy.
I'm scared. She just went down sleeping.
As we began the first part of our show, we talked about a 2008 case where we addressed the firearms risk warrant issue in Connecticut. And we're going to read from the transcript of that case, and Ed is going to be the part of the court, and I will play the attorney. And we'll read from the transcript of that case where that court specifically said that the community caretaking function justified the police officers' warrantless actions. And that case, as you indicated, was so frustrating.
No. Just hold on a minute.
Yeah, go ahead.
I understood exactly what the judge did. What the judge did was he politely said, go fuck yourself. The community caretaking function trumps the Fourth Amendment. Yeah.
Right. But now we
don't even have a pompadour here.
But now we have a justice on the Supreme Court, Justice Thomas, joined by all the other justices.
That's my man. Justice Thomas, he's my man.
That the community caretaking function does not do away with the Fourth Amendment when there's no other exception applies. So let's get back to the case. Okay.
My man Gorsuch, my man Thomas.
So Justice Thomas says in his decision that the First Circuit's community caretaking rule goes beyond anything this court has recognized.
Absolutely.
The decision below assumed that respondents lacked a warrant or consent, and it expressly disclaimed the possibility that they were reacting to crime. So what Justice Thomas is saying is that the First Circuit Court of Appeals knew the crime was not afoot, knew that there was no consent, and what was the third one, Ed? And knew that there wasn't a warrant. But still they said the police officers had a right to go in the house. The court declined to consider whether any recognized exigent circumstances existed. So there's no exigent circumstances, there's no warrant, there's no consent, there's no crime. But somehow the First Circuit Court of Appeals said it was okay for those officers to go in the house and seize the firearms under the community caretaking function. Okay, so Justice Thomas says neither the holding nor logic of this previous case that said when it comes to vehicles there may be a community caretaking function applied in this case. The location of the search in the other case was a vehicle. The location of the search in Mr. Caniglia's case was a home. There's
Attention.
There's a constitution.
Attention, counselor.
There's a constant.
I said attention.
You know, I should have never.
Some people live in their car. That is their home. And I would just everybody pay attention that if the accused was living in his car, then that is his castle. Continue.
Right, because in the previous case of Katie, it was an impounded vehicle with an unsecured firearm, so nobody was living in that car because it was impounded.
That's correct.
Good point.
Well, this judge has spent time in a motorhome. Just because it has motor before home doesn't mean it's not a home. So this case also involves motorhomes. So ordered. You're sorry you did this now, huh?
Yeah, so there's an unmistakable distinction between vehicles and homes. And I understand what you're saying. They're being a little too broad about vehicles because there's a distinction among vehicles depending on what their use is.
Look, this court recognizes exactly what the 9 justices were implying.
Right.
Okay? You can live in a fucking cardboard box on Skid Row in Los Angeles. That is your home.
Well, that's true.
That is true.
But,
I maintain there was a law.
But if your home is situated on property that is not your own, aren't you then part of the community?
Well, let me give you an example. There are laws in some states that you can't possess a firearm.
Where?
Right, it's like New York.
Outside the home.
You can't travel through New York with a gun in your car.
Well, you can if you're coming from a place where you can have a firearm and going to a place where you can under interstate traffic.
Well, let me ask you a question. I mean, God bless T. William Knapp, the former chief of the Wethersfield Police Department, executive director of Post, secretary of the Board of Firearms, and my mentor my entire life. He said, Eddie, you have the perfect case. You live in a motorhome. Do you have the right to possess a firearm in your home if your home is driving down the road?
I think that's a tougher question than if your home sits on your real property. Although an apartment doesn't sit on your real property, does it? It sits on private property.
Well,
I guess. Could be owned by
all
the
I
government.
know is if I ever get to be in the big house court, you know, the big court.
Oh, you're looking to be
I want to be promoted.
promoted.
Yeah,
What?
promoted from in the cellar to the courthouse.
Right, right.
You know, let me sit there for one day, and I'll tell you, you can bring 1,000 cases. I'll dispose of 1,000 cases in one day, and I'll be fair.
Now, would you mind doing it remotely, or would everybody have to come and appear right in front of you?
Oh no, I have to judge them. I have to. Yeah.
You'd want them right there.
Yeah, I gotta look at them.
Okay, so we're almost done with this decision. Let me see. What is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. We thus vacate the judgment below and remand for further proceedings consistent with this opinion. It is so ordered.
It is so ordered.
So Mr. Caniglia has a long way to go. He hasn't won yet. It gets sent back to the district court in Rhode Island. Maybe
Maybe they're going to dismiss the charges. 9-zip.
They might. Well, it would go to trial now because the district.
Yeah, let it go to trial.
It would
9
go to
zip.
trial.
9-zip.
But it might settle, so we can watch and see what
9-zip.
happens.
Yeah, we got to watch this case.
Okay.
Put out a Google alert for this guy's name. Spell the name for the record.
So earlier I was.
Spell the guy's name for the record so people can do a Google alert.
Oh, okay.
The case.
I have to pay more attention to you now, don't I?
Yeah.
I mean, you got that wig and you got that
Yeah,
black thing on.
I'm in charge.
To give him respect now. So the first name's easy to remember. It's Edward.
Oh yeah, Edward. That's a good name. So ruled.
The last name is Caniglia, Caniglia.
Is that the guy that was the Roman emperor and had all the sex?
Caligula.
Caligula?
Caligula.
That guy.
Yeah.
That's not the same guy, right?
Versus Robert F. Strom, Strom.
Now, who the fuck is Strom?
I assume he's some police official or the attorney general or, whatever. Some government official that was saying that the community caretaking function.
Okay,
listen,
I have to order. I order that every state in the union review their current laws, review their current pending criminal and civil cases, and apply the dictates of this 9-zip decision to whatever the hell they're trying to do. What do you think?
Yes. And I think we need to do that in Connecticut.
Oh!
Or I need to do
Oh,
it.
the Constitution. You're talking about the Constitution.
It's fun, but it's funny you should mention that, because I was thinking this morning how when seminal decisions come out like this, like
a semen decision?
No, seminal decisions.
Oh, seminal.
Important.
Seminal. Okay, I got it.
Like Caniglia versus Strom, we were talking about why don't states look at their laws? Like Attorney General Tong in Connecticut, he should be looking at this decision and instructing his assistant attorney generals to review state law to see if everything's in compliance with the United States Supreme Court. We know that he won't. Okay, we know that he won't.
The judge needs to speak.
Go ahead.
Hold your tongue.
Okay.
Okay. We have to start paying attention to the cases that are coming into our courts. Because I'm sure that the 9 Supremes were aware of other similar cases that had not made it to their doorstep and had not been selected or were never presented to them. These people, they got their clerks reading for them, telling them what's going on out in the country and, across the country. They know what's going on. And they know when a case, for example, how many times have I looked at a client of yours and said, oh, please take this further. But it's the client's decision, not ours. Okay? It's the perfect case to present to a federal court. But the client doesn't want the publicity. The client doesn't want to do this. And that's good. Get them the best deal you can. Get them off when they're due to get off. But I got to tell you, 9-zip is sending a message to the entire judiciary in the country. 9-zip. It wasn't even a split decision.
I know.
The liberals jumped on Thomas's decision. When is the last time you saw that?
Not only that, but the concurring opinions weren't concurrences by the liberals. It's Robert and Breyer that had a concurrence, Alito had a concurrence, and Kavanaugh had a concurrence. So the liberals jumped right on with Thomas in this decision.
Look.
So you ready to start? What we're going to do now is...
I'll try.
We have a transcript of a proceeding from 2008 here in Connecticut where the judge and I discussed the community caretaking function. And you'll probably be able to tell from the contents of the transcript the frustration that I had with pulling this community caretaking function basically out of, out of the air. Please, thank you very much. Because where had the Supreme Court or anybody ever said, well, I guess the First Circuit...
I rule that lawyers ought to be able to speak their mind and say whatever they want to a judge without fear of retaliation.
I mean, why don't we just call it the exception where the police can do anything they want any time they want?
No.
Why don't we just call it that?
That's covered by I don't recall. That's covered by I don't recall. The Fifth Amendment right against self-incrimination is to civilians, as I don't recall is to police officers.
Okay, so I'm going to give you this in writing, and I have it on my laptop. Okay, so I'm going to begin, Ed.
Yeah?
And again...
Well, it looks like you did most of the talking.
That's not
You
true.
must have been a big mouth in this courtroom. Oh, I think I was there for this.
Oh, you were there for this.
I know. Go ahead.
It's funny. 13 years ago this happened.
In the matter of Rachel Baird talking to the judge, the court is now in session.
Okay. So now this goes to the crux of the matter. Now, some police officers would disregard anything we may not pass here and would feel obligated under exigent circumstances. Just come through the door, get the guns, answer questions later. Representative Lawler, at least with regard to this case, foresaw the future because that is exactly what happened in this case. He said, I think that's a bad idea. We have an obligation to give the police officers some guidance on what they should look for and how they should proceed when they have reliable information and there's imminent danger present because someone has accessed the guns and appears ready to use them. Mrs. Doe didn't have access to the guns on May 8th, and she didn't appear ready to use them on that date.
Well, there was nothing in the affidavit that said she was trying to harm herself on May 8th. Was there?
Keep going.
But the affidavit said it was all from May 1st, right?
But on the affidavit on the front, when you say to the judge, you say, I have cause to believe that the above named person poses a risk of imminent personal injury to himself or other individuals. The above named person possesses one or more firearms, and such firearms are at the Connecticut State Police Troop.
7 days ago? You don't get a second chance in a situation like this.
I know, Your Honor, but that's not what the law says, because if you start down that slippery slope, then you just leave it in the complete discretion of the police. Oh, we don't get a second chance. We just get to go in. You know, nobody's going to question us because what if they're wrong? Then, you know, it's going to be on...
Well, wouldn't you better...
It's going to be on the front page of the newspaper.
Be better to err on the side of being wrong than being on the side of being right?
That's a real slippery slope. I mean, if we take that to its extreme, I mean, that just obliterates the Constitution, I would think, the Bill of Rights. Okay? There you go.
Well, doesn't a community caretaking function, which is an exception to all warrant requirements in the Fourth Amendment, provide for that?
I don't see in the
And it does. And it
discussions. I don't see in the discussions of the legislature or in the statute.
Doesn't it? Well, but they may not know about
I
it.
don't see anything about community caretaking in the statute.
This is a judicial fiat that came in the Connecticut Supreme Court and in the Supreme Court of the United States. And actually, it's a fiat that protects the officers so they won't be second guessed. Then when the bad thing happens, then the person, if they don't take the weapons, does something to harm themselves or someone else.
I just don't know where the community caretaking function ends. And I think whenever there's a principle out there, it's really quite dangerous.
You know, can you, with a straight face, say to me that you felt on the first that those officers shouldn't have grabbed those weapons from her? Her weapons, at least.
Well, I could say that with a straight face because it doesn't comply with the statute. Because the officers had exercised a reasonable alternative. They had taken her to the hospital. Keep going. Okay, so we're going to start over here now. What facts?
What facts did you have after May 1st that he should have known that she was not a risk of imminent danger anymore? Do you have any facts to present that he knew?
He should be asked that. He's the one that signed a warrant under oath.
All right, I'll ask it. Did you have any facts to show after May 1st that she was not in imminent danger to hurt herself?
Witness, no sir. And then Miss Baird, did he have any facts to show that she was?
Yeah, because on the 1st, she threatened to kill herself.
But But how far back does that go with imminency?
To the first.
Imminent? But Representative Lawler commented. Remember how he commented on you have to be brandishing the firearm or you have to be ready to shoot somebody. And on page 60 of the trooper's testimony, yeah, that goes into something else. So, Ed, I think that covers the portion.
I rule that 13 or 12 years from now, this will be decided. But not in this courtroom, not by me, not by the Connecticut Appellate Court, not by the Connecticut Supreme Court. It'll be ruled on by the United States Supreme Court, and Justice Thomas will write the main opinion.
In Caniglia versus Strom.
In Caniglia versus Strom.
Yep.
I think I just broke the desk.
I think you just broke my eardrums. But you know.
Order.
But in all seriousness, reading that, when that judge brought up the community caretaking function to justify what those officers did in 2008, I was speechless. And when the appellate court upheld
what would happen?
That decision.
What would happen in an NFL Super Bowl game if somebody was running towards the goal line and ran 10 feet outside the border, out of bounds, ran around the back of the bench and dove into the end zone? Would they call that a touchdown?
No.
Well, the community standard is it's a home game. Give him the benefit of the doubt.
Well, and if he ran that far, he probably could have run into the end zone too.
But the question is,
if
the person carrying the football in a Super Bowl game runs out of bounds and then crosses the goal line, do they have to bring the ball back? Or do they say, don't worry about it? He got the points.
But just compare what we wrote, what we read.
Every judge who has ruled in favor of community caretaking function to permit seizing something from someone's home without a warrant right now has egg on their face. Because it wasn't one judge that thought that, or it wasn't 5-4 that thought that, or 6-3, or 7-2, or 8-1. It was unanimous. It was a unanimous decision that you stay the hell out of people's houses unless you have a warrant. Unless you have, and I agree with this, exigent circumstances. Now, exigent circumstances. There's someone in the house, and there's a woman, someone's yelling for help inside the house.
Yeah.
Then you go in.
Well, you know, and the other frustrating part about this was earlier in part 1 of our show, I had read some statements from the state representative back in 1999 when they were passing the risk warrant law, and he said imminent danger to himself or others means he has to be getting ready to either kill himself or kill somebody else. You have to have firearms in your house. You have to be brandishing them. And in this back and forth with the judge in 2008, the whatever concerned everybody occurred on March 1st. They didn't do the warrant until May 1st. They didn't do the warrant until May 8th. And the judge is saying, do you have any evidence that she wasn't an imminent danger? No, the question is, do you have any evidence that she was an imminent danger? It was 7 days later. If you go by Caniglia, especially where it was the next day, it's just mind-blowing.
Okay,
and bear in mind that in the course of the testimony, it came out that the officer who wrote the warrant, the reason why it took so long to write the warrant from May 1st to May 8th, he was on his 3 days off. He was on his 3 days off.
Let me give you an example.
No. I don't care how exigent the circumstance is. I don't care who's in danger. That officer had his 3 days off, okay? You can't expect him to address exigent circumstances when it's his day off.
Let me give you an example. Because when we're talking, my mind's going 1,000 miles an hour all over the place.
I forgot to put my jacket on to be the lawyer.
So wait a minute. So hold on. Watch this. Let's assume that a man owns firearms and he stores them in his closet in his penthouse suite. He's on the top floor of a 15-story building.
Well, that's a penthouse.
He goes out onto the balcony and he threatens to nosedive off the balcony. he's a risk to himself. He's a danger to himself.
Well,
He's in danger to the people he may hit when he hits the ground.
sure.
Okay? So he's a danger to himself and others. I believe that law enforcement would be able to seize firearms. Now the question is, do you seize them with a warrant or not? Well, when they say exigent circumstances, here's what I've said 100 times. You took the person into custody, you put him in an ambulance, and you shipped him to the hospital. You seize the firearms and you take off. All you have to do is have one officer clear the house, have one officer secure the home, and well, because they have judges on duty 24/7. You can go back in your cruiser, type a goddamn warrant, okay, and have it signed by a judge, even electronically, can be signed by a judge, and you can go in the house and seize the firearms. We live in the 21st century.
Yeah, people don't want to take the time or make the effort, and you know why?
Shortcuts.
Because they know they can get away with it.
Exactly. And that's what happens when you have somebody who doesn't want to ask the question. Look, there's no doubt in my mind that day that the judge did not want to be the one who made the decision to give firearms back. He passed it up to the appellate court.
Right.
Even though it's going to cost the accused financially to get it up there, okay? It didn't matter. He did not want to make the decision. Now, I'm going to say one thing and then I'm done talking.
Oh, really? Okay.
No. I heard a story one time about they appointed people to be federal judges. People get appointed to be federal judges. And somebody assigned, a chief justice, I guess, assigns cases to whoever, or they're set up. I take care of New York and Connecticut, you take care of Florida and Georgia.
Where does this happen?
Either at the Supreme Court or in the Second Circuit.
No.
So, okay, here's what happened. A judge was assigned a very complicated case. It was going to take a lot of brain work to follow this. He didn't want to do it. He didn't want to do it, and he was told, you either do it or you get off the bench. That's your job, is to deal with tough cases.
So then what happened?
No, I don't know, but what I'm saying is a judge, I can't remember where it was.
Well, let me tell you. Okay, so in Connecticut, federal court in Connecticut, we only have one district. Bigger states have more, like California, Southern District, Northern District, Central District. We only have one federal district here in Connecticut. And supposedly, when you file a complaint, it's assigned a judge by a lottery system.
Okay.
So a judge could get a complicated case, a simple case, a pro se case, whatever kind of case. And you, unless there's a conflict, they keep them.
Right, and there's no getting out of it. You caught the case. And I'm sure that when I was up at the 9th, somebody by lottery gave me a judge that in the 3-judge panel, it was all put together by a lottery. I got a 2-to-1 decision, okay? And to me, it ought to go to an en banc everything, because if they're going to start saying, yeah, well, en banc, we can circumvent historical procedures by just going en banc all the time.
Yeah, I just disagree with you about that, because very few cases go en banc. I know yours did.
Oh no,
so it's
gun cases were.
Well, still, it's very few.
Okay.
It's so few cases that go en banc.
So I caught a unique situation.
You absolutely did, and so did the other case. Which one was it? Hawaii versus Young or whatever that went en banc. Same thing happened. Yeah. And it had a lot to do with the fact that it was the 9th Circuit and blah 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 and all that kind of stuff. But what you're saying, you might as well say, well, why even have district courts and circuit courts of appeals? Just let the Supreme Court decide everything. No, because it does ferret out the main majority of cases when 3-judge panels on circuit courts hear them. That's all there is to it.
I'm done.
Okay, so this is part 2, but it's not going to be a full hour.
It's okay.
But I'm glad we did it. I'm glad we did it because...
There's a phone call?
Oh. Take the phone call.
Hello, summary judgment.
Hello.
We're here. We weren't taking phone calls today. but from Midland, Texas, we take phone calls.
That's our exception.
Ex-Midland, happily now.
Hi, this is Joe, right?
Yeah, it is.
Hi, Joe. How you doing?
Oh, well, I'm alive and kicking, so I've been blessed with another day.
Good. All of us have. Good attitude.
All right, we're going to nitpick just a little bit more than the Supreme Courts and all that.
Okay.
Now, it is extremely rare, 9-0.
Oh, yeah.
Extremely.
Yep.
All right, so I am totally shocked on this.
Mm-hmm.
And the red tag law is not involved in this case, so the red tag is still going to stand on these states as has it. And I just want everybody to recognize and still remember one thing. The most important thing that you guys everybody needs to recognize, is the Supreme Court is only opinion. That's it. No more, no less. So, if there's anything that's unconstitutional, it's null and void. So, it's a guideline what states can do, you know, and they can really look at it, revamp the laws and all that to fit the opinion deal to make it work on their benefit. The Fourth Amendment, there's a period out there. There's nothing added to it. So if Congress wants all these extra added things that the Supreme Court keep adding into it, then Congress needs to do amendment to the Fourth Amendment and add it to the Fourth Amendment. Until then, everything that they've been doing anyway is null and void. Because it is unconstitutional.
You know, we're not going to change the fact that I am sitting here happy as shit to see a 9-zip decision on Fourth Amendment violations.
On the people's behalf.
How many what?
On the people's behalf. It wasn't the government's behalf, it was the people's behalf. That right there is right.
Yeah.
On top of everything there.
There are people in this country who have been torn apart by violations of their Fourth Amendment rights. And now, somebody has addressed the Fourth Amendment. And you can't, I'm sorry, but the Supreme Court can't speak any louder than 9 voices saying the same thing.
And I think every state's red flag laws are different. Here in Connecticut, it may make a difference because in Connecticut they certainly do rely on community caretaking function in enforcing the red flag laws, simply because we've perverted them to be that although the statute says you have to have a warrant, they don't use a warrant. So that makes it go into the realm of community caretaking. But every state statute is different, and even Connecticut's may change where a warrant isn't required. That's before the legislative session now, so I don't know how that will affect things. But yeah, right now, Joe, we are basking in this 9-0 decision. But you're right. It doesn't solve everything. It probably doesn't even solve anything if you want to get right down to it.
I said nothing.
I don't mean to destroy this judgment whatsoever.
Right.
Or this opinion.
Yeah.
It is a blessing to the people.
Well.
And we need more of this.
I think
for the people and not for the government.
The Supreme Court.
I just wanted to stretch and let people know that these things that the Supreme Court actually do cannot and should not be any type of law. There are opinions. And, you know, everybody says, well, the Supreme Court is the law of the land. No, they're not.
Joe?
Yeah, and
they're not, what did he say they were? Opinions?
Opinions.
Okay. They're not opinions, they're interpretation decisions. They're decisions, not interpretation. They interpret, but they issue. Okay.
Well, the interpretation is their opinion.
Right, but when you I have a hard time, getting away from the fact that 9 people came together
Yeah.
I can't remember the last time there was a 9-zip decision.
Well, on constitutional issues, it's tougher. You're right.
Absolutely.
Yeah.
Absolutely.
Other decisions, yeah, it
Because
happens.
what they were doing was they were very loudly telling the federal court system, okay, that you can't do this anymore.
In other words, there's an end point. You know, before I don't think there was any end point, but there's an end point.
There was a case out of Texas where a photographer won his case but won no damages. What the court said was, I'm not going to give any damages to this photographer, but whenever a case like this comes for us in the future, it's open season on the people who do it.
Yeah, right. A right
Okay.
to video record the police.
Right.
Yeah.
So I'm sitting back saying to myself that I've been raised to believe that you have to have a warrant to get in somebody's house. Now, as an adult, I found that there were reasons to go into a house without a warrant. A person is screaming for help, claiming to be they're being assaulted, they're being raped, they're being murdered. You bust down the door and you go in without a warrant. Okay? Those are exigent circumstances. But what I'm saying is, there's shit going on in this country, and I gotta watch this. The liberal side of our society, the far left people in our society, have to be looking at this decision and saying, what's going on here? But the conservatives are also looking at that, saying, well, we want to go into people's houses and take shit. And you know, we want to be able to just walk in and then come up with some story to control the narrative. You know, this is what happened. Until their body camera video comes out. It's changing, Joe. It's changing faster than we can keep pace with it. It's going to change.
Yeah,
Here's what's coming. Here's what's coming.
We actually have a fairly good Supreme Court system right now because they've been really pretty good on being into the constitutional issue. You know, like in December with that abused prisoner, you know, well, no, qualified immunity don't work with this. This is just common sense. You don't do this. So the Supreme Court was on, you know, that and said that qualified immunity will work.
I said nothing about some things that I'm aware of in today's show.
Mm-hmm.
So I'm going to end it by saying to you in Midland, Texas, or in Texas, let's just say Texas, the Supreme Court has agreed to hear a firearms permit case out of New York. I think that they're going to interpret the Second Amendment saying that people have the right to keep and bear arms. Period. Okay. And
I got one more thing.
Go ahead.
In Kansas, they literally passed a law saying no more no-knock warrants. So we are all heading in the right direction.
Right. Now, unless you're a policeman, but let me say something else. This Supreme Court has also agreed to hear a abortion case that they say would give them an opportunity to, if not overturn, to substantially change Roe v. Wade. Okay? They've accepted a case that would give them an opportunity to tinker with that. Now, I have no opinion on Roe v. Wade. I have no opinion. I believe that a woman's body is a woman's body, and that's going to come out in the long run, but all I can tell you is I bask in May of 2021 in a 9-zip decision by the United States Supreme Court. And I want to see how many people now interpret that and carry it to other areas, okay, of home.
Well, the newest judge we have, and I can't think of her name, she goes by president. So, gonna have to scratch her out, so it's gonna be a minimum 8-1.
Mm-hmm.
Then there's going to be a couple of other judges. I'm looking at maybe 6-4.
Some decisions
Or
should
6-4,
never have been
sorry.
made the way they were made, and people are willing now, I believe the Supreme Court has some people on the court who are willing to go back and say that was a mistake.
Well, that just supports Joe's earlier comment that, you can't get that excited about Supreme Court opinions because you have to put them in context. Those are human beings. They have their biases, they have their opinions, and they interpret the law, and they can't separate themselves from the fact that they're human beings. And certainly, the Supreme Court has totally reversed itself on a number of laws. A number of rulings. It's totally reversed itself. So it could do that again. So it's not like it's written in stone.
I don't think that this topic is over on this program.
Mm-hmm.
I think that this topic is going to carry us forward into other shows.
But what I'm going to do when Joe hangs up, I'm going to go to that case out of the 10th Circuit, United States versus Carlos, Carloss, and Justice Gorsuch wrote a dissent when he was on the 10th Circuit Court of Appeals back in 2016, where he addressed the knock and talk, which I call the consent exception to the Fourth Amendment. And when I read that dissent by him, I thought, this is a guy that I want on the Supreme Court, most definitely. I really like Justice Gorsuch. Justice Kavanaugh.
How can anybody be sitting on the Supreme Court who was raised in the time that they were raised and not have been taught that the home is a sacred place that can only be violated with a warrant?
Right.
In other words,
Well,
kids growing up today, they probably think the cops can come in the house anytime they want.
yeah, no, some people.
Yeah. And I'm shocked because that's not the way I was raised. It wasn't what I was taught. Even in a police academy, they didn't teach me that. They told me I had to have hands off. I couldn't go in unless I had a warrant.
Mm-hmm.
So with that, I think we're all done.
Uh-oh. Okay. Thanks so much for calling in, Joe.
Joe,
Say hi to
stay
Wade.
safe.
Yep.
Bye-bye.
Stay safe and healthy.
These are we the people. News.
Bye-bye.
Thank you.
Bye, y'all.
Well, I got to tell you, Ed, I can sense truly that you were overwhelmed by this decision,
Oh!
and I am too.
Because I watched you suffer emotionally when you knew you were right. What could you do? They're judges. Hey, you motherfucker, you got it wrong. You don't understand.
No, there's no, that's not even.
It doesn't work that way.
That's not even something that comes into your head to say. It's just frustrating because you feel like you're not successful in getting your argument forward. You feel like somehow you have failed to convince them, but people have different opinions and interpretations of things, and sometimes it takes us to get to the United States Supreme Court. But bear in mind that people who don't agree with this decision, people who have adopted the community caretaking function as an exception to the Fourth Amendment, will attempt to distinguish other cases from this and still uphold that. Oh, well, in Caniglia, the circumstance was a little bit different, and that's why the Supreme Court said this. But in this case, Miss Baird, we don't have that. This is different, so we're still going to apply it. And that's what being a lawyer and being a judge, and that's what our justice system is all about. So there's never any certainty.
I enjoyed this discussion today. It was something that I have had eating at me for years.
But we're exhausted, so we're going to sign off today, and thank you for joining us.
See you next week.
See you next week.